Sorry about that, guys. So appreciate Rachel and her ability to be able to restart the meeting. Not sure what happened, but we did have another call going on at the same time. So hopefully you can hear clearly now, and we won't have that interruption again. So here is our agenda, and as I was saying, we're going to talk about the Uniform Commercial Code. We're going to talk specifically about Article 9 and what the definition and the scope is of it. We're going to talk about UCC 1s and UCC 3s. We're going to talk about the names that go on the UCC, the debtor name, the secured party name. We're also going to cover the collateral information and talk just a little bit about search methodology. And if everyone who's on, if you're on a phone, if you could just make sure your phone is mute, that would be great, because I'm still hearing some noise. All right, so let's go ahead and go on. All right, so when we talk about Uniform Commercial Code, or the UCC, I always like to start by saying it's anything but uniform, so it is misnamed. There are a lot of variations in both the searching and the filing of UCCs. But as a definition, Uniform Commercial Code was established back in the 60s, basically to help transact business across state lines. So that if you were doing work in Florida or you were doing work in California, it would be the same type process that you would need to go through. And it was a way to kind of harmonize that business transaction across the United States. It is divided into different articles, and we are talking about Article 9 today, because Article 9 is the one that has to do with secure transactions. So when I'm talking about these guidelines that have been put out by the different organizations that have developed the codes or the guides for it, it is just referencing Article 9. And we will talk about that more as we go through. So when we talk about Article 9, there are certain committees that I feel that if you want to know all about UCCs, you might need to know. These are the different committees that come together to create the forms, or to make changes in the forms, or to make changes in any of the guidelines. They just meet at a certain interval just to make sure the process is going smoothly, to look at certain cases that maybe have come up recently, to see if they need to tighten any language or anything like that. These committees are made up of attorneys, people from different jurisdictions, people from companies like mine. So there's a group of people that get together and actually put these guidelines together, and then they push them to the jurisdictions, where the jurisdictions get to decide how they want to enact them into their jurisdiction. And that's where we come up with the non-uniformity, because some of the jurisdictions will take some of the guidelines, and some of them will say, that doesn't work for us, we're going to change it a little bit. Here's a timeline, and I'm not going to spend a lot of time on this, but just so you know a little bit about the history of Article 9, it really came into its major people were really using it at the end of the 1960s, and then in 1972 it did have a major revision, which I can happily say I don't remember, but I do remember the revision of 2001, and it was a major revision. If anyone worked on UCCs prior to 1, then you may know about the 5-part forms, and every state had their own form. You filed wherever the collateral was located. You had to get signatures on the UCC. So there were a lot of things that made it a much tougher process than it is today. In 2001, with the revisions, it took away the need for filing wherever the collateral was located and the name signature. The 5-part form that was white, pink, blue, green, and yellow, I think, was done away with, and now we have, of course, the national form. In 2013, there was another revision, but it was very minor. It just kind of tightened up some of the language that was put in place in 2001, and that was just based upon what the committees were saying as far as the cases that were coming into the court. When I talk about Article 9, I do want to make it very clear what it applies to and what it does not apply to. Article 9 applies to any consensual transaction. So a debtor and a secured party decide to go into a transaction with a particular piece of collateral. That is covered by everything that I'm going to talk about today. It will cover personal property, It will cover some fixture filings, and it covers generally lease, consignments, and bailments. What is not covered under the guidelines I'm talking about today is any non-consensual lien. So nobody wants to go into a lien with the state or with the federal government, or mortgages. All of that is governed by different laws, and so what I talk about today only applies to what I'm going to directly address as we go through the seminar. So let's start by talking about a UCC-1. A UCC-1 is going to be the first thing that you file when you're creating a UCC. It is a legal document and is publicly filed. One of the main purposes behind the UCC process is it's a notification system. So you as a secured party file your UCC to let the next secured party know that there's a UCC out there with a particular debtor and with particular collateral that's being pledged. So it is filed publicly so that other people can access it. It is a standard form for the most part, national form that's used across the United States. We do know that New York is still using the old national form. In 2013, they pushed through a new national form. New York has not adopted it yet. Of course, for those of you in Florida, you know Florida has your own form, but you also accept the national form. The UCC-1 is not necessarily just the face page of the UCC. It may have other information that's attached to it. It could have an attachment. It could have an addendum. It may have something that alters the original one. So when we talk about the UCC-1, it's not just the face page, it's anything that's related to that particular document. And if you don't hear anything that I say today, this is the one thing I want you to remember. Your UCC needs to be prepared against the exact legal name of the debtor. And we're going to talk about that in more detail as we move through. That's going to be the most important part of your UCC, because remember, other secured parties have to be able to find it. So you have to be able to prove you have the correct and exact legal name of the debtor. Let's talk for just a minute about who has the authority to file a UCC. Believe it or not, this does have to be part of the code because there are people out there who will fraudulently file UCC. And while it is not legally binding, it does become part of the index. If you've worked much with UCCs or you've worked much with jurisdictions at all, you know that when you submit a document to them, their job is not to police that document, to know that you have the right secured party, you have the right debtor, you have the right collateral. They just file it. So when someone is fraudulently filing a UCC, that is also indexed. So the problem becomes that whoever it's filed against may have to get it cleared up before they can move into their next transaction or buy a home or whatever they might be looking to do. We have seen cases of where these have been filed against prison wardens. We have seen it against government officials, and we have also seen it against movie stars. So if we have one case out of New Jersey where a man was being followed, or the IRS was after him because he owed back taxes, he started filing UCCs on the people who were calling him about those back taxes. So it does happen, and they do put in the guidelines who has the authority. And basically, to sum it all up, the person who has the authority is whoever's been given the authority by the debtor. Generally, it's part of your security agreement. And once the debtor signs that, they've given you the authority to file, as a secured party, to file the UCC. There is something that's called pre-filing, which you may hear about. Pre-filing enables you to file the UCC prior to the closing. I've heard a lot of mixed opinions on this. Some people love it, some people don't. Banks like it or don't like it. There's a lot of varying opinions on it. There's no right or wrong way to do it. The problem with pre-filing before the 2013 changes is it wasn't official that it was actually an official UCC until they put in the guidelines that it was, which means if for some reason your transaction does not go through, you do have to go back and file a cancellation or a termination on that particular UCC. So let's talk about where you file your UCC. It's going to be based on your collateral. So personal property, you would normally file wherever the central filing office is.
So personal property normally is filed at the Central Filing Office, which may mean the Secretary of State in most states. However, there are variations. I am in Georgia, and everyone who is at Nelson in Georgia or has ever done filings in Georgia, you know we do not have a UCC division of the Secretary of State in Georgia.
So you actually file at the county level. So there are even variations. Louisiana has parishes. So there's some variations in where you file, but generally personal property is going to be filed at the Secretary of State office. Real estate related, so if you have a lot and a block and a legal description, you're going to be filing that at the Central Filing Office, so the county level. And then transmitting utility, if you work much with transmitting utilities, you will find that people do it differently. Sometimes they will file the UCC wherever the utility is running through. So if it's running through several counties or several states, they may do a UCC in every one of those locations. Just remember, it's okay to file multiple UCCs. If there comes time when you're maybe not 100% clear if you should be at the state or the county, or maybe you're working with an individual name and you're not sure exactly, maybe they live 6 months in Florida and 6 months in Michigan, it's okay to file multiple UCCs if you have a question about it.
So we are on to polling question number 1. Here is the question. If you are filing a UCC on personal property, you should file your UCC at A, the Central Filing Office or the Secretary of State, B,
the local filing office, meaning the county office, C, the Central Filing Office and the local office, D, correct location is usually the Secretary of State, but can vary by state.
So again, if you are wanting CLE credit, then you will need to answer this question. And I believe that Rachel has put it into the chat area, and you should be seeing it, and then you can respond. All right, so one more time, I will present the question. I hope that it's coming up properly for you guys. If you are filing a UCC on personal property, you should file your UCC at A, the Central Filing Office, B, the local filing office, C, the Central Filing Office and the local filing office, D, correct location is usually Secretary of State that can vary by state. All right, I am not sure if we got the results of that or not.
Beverly, I can tell you that 64% of the audience voted for D.
Yay, great. Good, that is great. Thank you, Rachel, for sharing that with me. That is the correct answer. Yes, as I mentioned, Georgia doesn't have a Secretary of State, so you file at the county. Louisiana has parishes, so it can vary by the jurisdiction. So great job. All right, let's go on. Let's talk about what is the location of the debtor. When you're filing your UCC, you need to make sure that you file wherever the debtor is located. Well, you need to know what is the definition of that. So when you're working with a registered entity,
it is wherever they're organized. So if I was doing a UCC on Home Depot, I would file my UCC, even though they're headquartered here in Georgia, I would file it in the state of Delaware.
If it's a non-registered entity, maybe it's a flower shop or a local deli or whatever, you would file at the Chief Executive Office. If it is an individual, you're going to file it wherever the debtor resides, and we're going to talk more about individuals in a minute. If it's a foreign entity, meaning it's outside of the United States, you will first look at the home country's filing system and see if they have anything that's equivalent, remembering, of course, that the whole UCC concept is an American concept. But you would first look and see if the country has anything. If not, you can file in the United States at the Chief Executive Office, or oftentimes people will file in Washington, D.C. So let's talk for just a minute about paper filing versus e-filing. This is something that has come up more recently, especially with the
changes that have the pandemic that's been going on and the changes at the different Secretary of State offices where, you know, you can't go in and hand deliver things. How do you get the documents to them. More and more people are doing electronic filing. And because of that, and I'm not saying one is better than the other by any means, but I do just want to point out some of the differences that you may encounter when you're doing e-filing. Maybe you haven't done this in the past, and now you're being kind of pushed in because of what's going on into doing it. So let's talk about what you may see different in e-filing versus paper filing. So when you're e-filing, we do know it's faster. If you have ever e-filed before, you will know how quickly those turn around. Now, different jurisdictions will have different amount of time. Delaware is extremely fast. Some other jurisdictions, their e-filing is within 24 hours, so you may not get it back quite as fast. Oftentimes, electronic filing is going to save you money. In Delaware alone, if you're electronically filing, you will save $50 on their jurisdictional fee.
But remember when you're e-filing, and this is the question that I have gotten from people who are not familiar with it, and then they get the acknowledgement back. If you are one where everyone needs to sign off on what you're submitting, know that when you e-file, sometimes that acknowledgement is going to come back looking different. So if you're a big stickler for it, making sure that when the acknowledgement comes back, it looks like exactly what you submitted, you're probably not going to want to do e-filing because there are oftentimes changes based upon the jurisdiction. There are also attachment issues. For those of you in Florida, you know when you're doing e-filing, they don't want you to have an attachment. You can have an addendum, but they don't want you to have an attachment when you're doing electronic filing. Also, if you have multiple secured parties, sometimes authorizing the parties, if it's a termination, for example, or an amendment, and you need multiple secured parties to authorize that, that can sometimes be a burden. And then also debtor identification. And what I mean by that is if you're working with a transmitting utility or it's a manufactured home or something like that, sometimes it's difficult to identify them depending upon how the jurisdiction has actually built their electronic filing system. So when we talk about paper filing, we know that when you submit your paper filing, you do have a second set of eyes on it. The attachment is always accepted. There's not a problem with that. The acknowledgement is going to come back looking like what you submitted. And of course, the problems with the multiple authorized parties or the debtor identification is not an issue. Again, electronic filing is wonderful, paper filing is wonderful. I'm not saying one's over the other. I just like everyone to know that there may be some difference if you're not familiar with it. Let's talk for just another minute about non-U.S. debtors. When I was talking just a few minutes ago about it, I was saying that you may have some jurisdictions that have something similar to ours. There is a three-part test that a country can be taken through to identify if they actually have a UCC system like ours. One is that they have a way for you to file and to record your document. Obviously, that's what we do in the United States. We file the UCCs and we record it. Why do we do that? So that other people can find it. So there has to be a way to search that particular system, that it is available for them to find. And you have to be told that you need to register that. So you create the document, you register it, and then it has to be searchable. And when we look at this three-part test, there are actually only 3 countries that we can identify that have a UCC processing system similar to ours: Canada, Australia, and New Zealand. Those are the 3. There are other options for you, so don't think if you're working with international debtors that you're out of luck. There are other options that you can get. They have a variety of different documents that are available. The credit reports are going to look similar to what we have here in the United States as far as credit reports, but you can do a bankruptcy, litigation, asset. So know that you're not tied to not being able to do anything similar to a UCC in other countries, but you may have to know the different terms and the different ways of getting that document filed or processed. Let's talk about legal sufficiency on a UCC. There are 3 things you have to have on your UCC in order for it to be legally sufficient.
One is the debtor's name. As I said earlier, if you don't remember anything else, the debtor's name is the most important thing on your UCC.
2 is the secured party name. The reason the secured party name is on there is that if the next secured party who may be entering into a transaction with this particular debtor has any questions, they have to have someone to call. So the secured party should be on there as the one who can answer those questions for them. And then the third thing you have to have is the collateral. On the face page of the UCC, all that you have to have is an indication of the collateral, and we will talk about that more in a minute. Let's look at a case where the new secured party didn't actually do all of their due diligence. This is a case involving New Holland and John Deere and the same debtor. John Deere had an existing UCC out with a particular debtor, and New Holland wanted to enter into a transaction with the same debtor. They saw that there was a John Deere UCC out there. They were told by the debtor and the bank that it had been satisfied. They didn't bother calling John Deere. They didn't, try to get any more additional information. And when they actually filed it, when the debtor defaulted, they found out that, in fact, the John Deere UCC was still active and it was not satisfied. So in this case, the courts had to decide who has first priority to the equipment. The ruling was New Holland had all the information they needed. They just didn't do the work that they needed to do to gather all of it. In other words, they needed to call John Deere. They were listed on, as a secured party on the one they were questioning, and they could have answered those questions for them. So in this particular case, John Deere had the first priority. All right, let's switch over to UCC 3s. There are 4 things that a UCC 3 will do. It can amend your UCC 1, it can continue it, assign it, or terminate it. Of course, anyone who has done UCCs before knows that your UCCs will last for 5 years, generally. There are some jurisdictions that are longer. Again, anything but uniform. You do have a 6-month window where you can file a continuation if it's a UCC that needs to go for another 5 or 10 years. In that 6-month window, it's 4 years and 6 months in, you can file your continuation. This would be about the only time that you would get a rejection from the jurisdiction. If you try to file outside of that window, they're going to return it to you. They won't return your check if you send them a check with it, but they will return the UCC and let you know that it's rejected because you're not within the window. It's either too early or it's too late. If it's too late, your UCC will need to be refiled. You can, of course, assign a UCC with an amendment, and then you can terminate. Just remember, when you terminate a UCC, because it lasts for 5 years and someone pays it off in 3, so you want to go ahead and terminate it, it is going to remain on the public record for 1 year. So you will still have the option to see it, but it will be listed as terminated. This is a UCC 3 form, and hopefully you can see it. It's kind of a little blurry. But once you get past the UCC 1, you start working with the initial financing statement number. So you'll see that in line 1A, that's where you would put in the financing statement number. Your UCC 1 will be stamped with a number and a date, and you would put that information in, and then you would decide what you're going to be doing with this UCC 3. Are you going to terminate, assign, continue, or amend? So you have the option to pick each one of those. And once you do that, if you're amending, you have to put in, or assigning, you have to put in the current information and then the new information. If you're terminating on down the form, you're going to see a place where you have to have authorized party. So your secured party would have to be listed there. Actually, if you're doing any of these, you have to say who is authorizing this change. Let's look at the case of GM for just a minute. And many of you have probably heard about this. This is a case that happened in 2015. It's a little dated, but I will say not a lot of exciting things happen in the world of UCCs. So when a big case like this happens, we kind of hang on to it for a while. And if you don't know, GM actually had 2 different loans with JP Morgan. One was for $300 million and one was for $1.5 billion. Upon maturity of the smaller loan, they wanted to go ahead and terminate the $300 million UCC. Okay, that's fine. But what happened is the UCC was actually prepared to terminate both of the UCCs, the $300 million and the $1.5 billion. And they were filed. Everybody reviewed them. The counsel from JP Morgan, the people at GM, law firm, everyone looked at them. They said it was great. Go ahead and file them, and they filed it. Obviously, they didn't mean to file the $1.5 billion umbrella UCC. Shortly after that, GM filed for bankruptcy. So JP Morgan came up with some different ways to see if they could work around the fact that they had actually filed a UCC termination, which they didn't mean to do. They talked about how they weren't really authorized to file it, wasn't really effective. But upon looking at it, the court system said, you know, regardless of your intent in this particular case, and if you've worked much with fixture filings, you know that intent is a really big thing when you're talking about fixture filings. But when you're talking about UCC terminations, it is not as prevalent as the fact that everybody agreed to it, everybody signed off on it, and then you guys actually filed the termination. So it was considered terminated. There have been several different things that have come up since this case. Recently, we found out that there were actually fixture filings in the $1.5 billion UCC.
And so they did go back, and there's a whole nother case about how they tried to get some money back from the fixture filing, but obviously not 1.5 billion, but they were working on that. So there is, this story just keeps going. And because of this story, before I move on, some law firms have actually changed their processes. We now see where some law firms are requiring that multiple people view the UCC before it's actually filed. And that may or may not be something that you guys have put in at this point, but we have one firm we work with that the UCC actually has to go to a central office, and it is either filed from there or it's reviewed and it's okayed and then sent back. So it can vary depending on it. But because of this case, some people have changed their process. So let's talk about the debtor name. When we talk about the debtor name on your UCC, there's a couple of things that I need to point out. I've already told you it's the most important part, so I won't talk about that anymore. But in 2013, there were some revisions made to 9-503, which made the language about where you get your debtor name a little bit stronger. And the way that they did that is you'll notice in the highlight, you'll see public organic records. Prior to 2013, the only thing that this guide 9-503 said was public record. That leaves a lot of room for interpretation. And so people were going to various sources to get the name of their debtor. And therefore, when particular cases were brought in front of the court, they had nothing to actually lean on. So in 2013, they added the word organic, and they added this information about it, saying specifically it is the formation documents that were filed when they were organized to do business in a particular jurisdiction, and anything that has been filed that may alter that name. So you know if you're working with a name, a company that's 50 years old, they may have changed their name 5 times. So the secured party is responsible for reviewing all of those amendments and making sure that they have gotten the most current name filed on their UCC. This is probably the area where I get the most concerned when I'm face-to-face with people, which I wish I was face-to-face with you guys today, but I can't do that. There's a lot of people who are getting names from different areas. I had one company that I was working with, it was a corporation, that told me they were getting them straight off their lease agreement. So they weren't confirming them at all with the formation document. Here is the official comment that's in 9-102, and it says specifically some things that are not considered public organic records, because this is some of the most common places people were going to get the name. The certificate of good standing, or searching a published index of domestic corporations. So maybe you go online at SunBiz, or you go online at Secretary of State, and you find a name, and you use that name. That is not the proper place to go to get the name for your UCC. And they actually put in a definition, again, for it in 9-102, that again states it's the formation documents that are filed when they're organized to do business and any amendment that could reinstate the original name that was put in place. And they're really tough on even punctuation and spaces. And let's just look at this next polling question. Polling question number 2. The debtor name for a UCC filing should be obtained through A, a thorough questioning of the debtor, B, a good standing certificate, C, the formation document and all amendments, D, an online search conducted at the Secretary of State. So hopefully Rachel is going to push that out. There it goes. All right, so let me read it again. The debtor name for a UCC filing should be obtained through A, a thorough questioning of the debtor, B, a good standing certificate, C, the formation documents and all amendments, D, an online search conducted at the Secretary of State. And we'll give you a minute.
And Rachel, once you close that, if you want to let me know.
I believe 63% of the audience chose C.
Right, C is the right answer, yay. Right, you don't want to do a thorough questioning of your debtor because we all know that half the time our debtors do not know what their name is really. Of course, the good standing certificate we specifically said is not the proper place to go, or searching on the Secretary of State website, so great job. There is errors and omission that's pointed out in the guide 9-506, and basically it says that your UCC is not going to be seriously misleading if you've
done the street number wrong or the zip code wrong. But it will be deemed seriously misleading if the debtor name is wrong. And that's where you will run into problems. Oftentimes people don't really think about this too much until things are headed south. In other words, you've found an error and it's been challenged. Then they're going to go back and find out where you got that debtor name from. And that's where it can be troublesome.
Let's look at a few examples of debtor names. This first case is from Nebraska, and it's Alva Grain A&D Feed, Inc.
When it was filed by the secured party, they decided to change the and to an ampersand, and they filed it. The problem is, because Uniform Commercial Code is not uniformed in filing or searching, in Nebraska, the search logic does not use the ampersand and the and interchangeable. Even though it should, it doesn't.
So this UCC was deemed seriously misleading because they used the ampersand instead of the and. Another case is a UCC one that was filed in Wisconsin, and the debtor's name was ISC, Inc., period. And if you guys notice, if we were face-to-face, I would say, okay, what do you see that's different in the third line?
All that is different is they left a space between the C and the period. And because of the search
logic in the state of Wisconsin, that caused a problem with the ability to be able to find the name. So it was deemed seriously misleading. Lastly, here is another one, and this I often get questions about. The debtor's name was BFN Operations LLC, but the secured party decided to add another name onto the BFN Operations LLC. If they had left it just like that, they would have been fine. But when they added the
doing business as, or also doing business as name, or formerly known as, any of those things that you add, then it changes the name. I tell people if you need to add a DBA name because you're afraid people won't find it by its corporate name, maybe it has a more individualized name that you need to list, you can do that, just not on the first line of your UCC. The first line of your UCC where you're putting in the name needs to be the name from the formation document. If you want to put something in the second line, heaven knows you can have as many debtors as you would like, so you can add different names, but make sure the first line has the name of the UCC as it is on the formation document. In this particular case, this UCC was filed in Tennessee and Michigan, and it could not be found because it had the additional wording on the end of the name. So remember, it's not like a Google search. It's not going to search all around. You do need to make sure that you have the search just as it is on the formation or the name.
So let's talk about individual names for just a minute. Hopefully you guys don't have to do too much with individual names because they can be pretty tough to work with. In 2013,
the creators came up with alternative A and alternative B, but they couldn't decide which one to put in place. So they kind of pushed it out to the jurisdictions and said, you guys decide. So let's quickly look at alternative A. Alternative A says it's the only if rule. You go to the driver's license to actually get the name of the individual for your UCC.
Excuse me. And most states adopted alternative A, meaning you needed to go to the driver's license and find the name. Alternative B is more of a safe harbor. You can go to the driver's license, but you also can go to other items to find it. Maybe the checking account or the Social Security card or, you know, whatever, their tax documents. You can go to different places to find the name. So that's more of a safe harbor, and it's used, but not as much as alternative A. And if you ever want to know who has alternative A and who has alternative B, please let me know because I can get you a chart that shows you that information.
So key issues to remember when you're working with individuals is that driver's license, even in alternative A, need to be issued in the state where you're doing the filing.
Of name changes, if someone has gotten married or divorced or something of that, and they may have changed their name. Some states have multiple IDs. Use the most recent version. Cultural names. Sometimes it's difficult to know the first name from the last name, so you have to be careful with those and make sure that you've talked to your debtor or looked at the driver's license to make sure you have the name right. And then remember, when you're in doubt, you can file against multiple names. As I said earlier, you can put as many names on your UCC for the debtor as you want.
You can even go to an addendum page and keep adding names. So you can do multiple names. If you have someone who lives in Florida 6 months, in Michigan 6 months, and you want to file in both places, you can do that. That's not a problem. It's just a way for you to make sure your UCC will be filed in either location.
Here is an example of a individual name that was not filed correctly, and you'll see it was Andrew, F-U-E-L-L, but when they filed it, they left off one of the L's. And so in the state of Idaho, this was deemed seriously misleading, simply because it could not be found in that way. Okay, so let's talk about secured party information. Your secured party information is laid out in 9-102 and 9-511, and it does talk about, you know, the secured party is who favor of security interest is
created or provided for under a security agreement. But then it also talks about what the security party needs to be as far as on the UCC face page. And it can be a secured party of record. And this sometimes will happen. And you may see when you're looking at a UCC that the secured party is a company like the one I work for, or maybe someone else who does similar work to ours. This is perfectly fine. It's outlined in 9-503 that it doesn't have to be the exact true secured party. It can be a representative of the secured party. And that's what this example is showing. As long as the representative can answer your questions or point you in the right direction, then you can list different names. Why would someone do this? I worked with a company here in Georgia who was in a very competitive industry. They felt like if they listed their name on all of their UCCs with their debtors, that somebody could in turn go in and do a secured party search by their name, uncover all of their UCCs and the debtors, and possibly pursue their customers. So they wanted to use representative as their name on their UCCs, which is what they did.
Another thing I'm going to point out about secured parties is when you are filing, mostly point out with terminations. If you're filing a termination and there are multiple secured parties, remember each one of them has to authorize that termination.
Otherwise, it's not truly terminated. So if secured party number 1 terminates their portion of that UCC and secured party 2 and 3 do not, that is still an active UCC.
So just remember that everyone has to give the authority to terminate a UCC. Sorry, guys, I had to get a drink there. Okay, so when you're talking about secured party, you can rest assured that that is not going to be a reason for your UCC to be deemed seriously misleading. You should have it correct, and you need to have it correct, but it's not going to be a reason for your UCC to be, seriously misleading it, and you lose your priority. But obviously, if you're doing a UCC, you want to make sure that if that secured party name changes, that you go ahead and update the UCC by doing an amendment to make sure that the most current information is on there. Let's talk for a few minutes about collateral. That is the third thing that has to be on your UCC to make it legally sufficient. The collateral, there's 2 descriptions for it. You guys have all seen security agreements, and you know sometimes those can be 10 pages long and very, very detailed. You don't have to put all of that with your UCC. In fact, you don't even have to have an attachment, as you probably know at this point. Excuse me. The collateral description on the financing statement is outlined in 9-504, and it talks about that you only have to have an indication
of the collateral. There's no true definition of the indication of the collateral other than that there needs to be, and we've seen this in different case law now, there needs to be a strong key word that's going to indicate to the next secured party what kind of collateral it is. Is it farm equipment? Is it a printing press? Is it widgets? What is it that they are actually pledging here as collateral? So there does need to be a description of the collateral information that gives some kind of a key idea.
So here is a UCC that did have to do with a large printing press, and this one was in Florida, and it was a UCC that was pledged with attachment pages that on the face page of the UCC, all they indicated was a large printing press. What happened is in paragraph 9 of the attachment, there was wording that actually made it a blanket lien. So because the secured party who was coming behind them took what was on the face page and said, this must be it, and didn't do any more due diligence, then what happened is they ended up not being able to, it was a blanket lien that was valid. So in other words, creditors have to be, people who are coming behind others on UCCs have to be careful to look at all of the attachment pages to actually make sure that the large printing press is all that there was, and not that in paragraph 9 there wasn't hidden blanket information. I have had people send me,
a couple of people have sent me documents and said, this is what we put on the face page of our UCC, but I think in this paragraph, this makes it an all asset. What do you think? And sure enough, it does. So just be careful when you're looking at UCCs that you look at all the attachments.
Let's talk for just a minute about searching. And when we talk about searching UCCs, we know that generally you're going to search in the Central Filing Index. Even for Georgia, where we don't file at the Secretary of State, we still have a Central Filing Index for searching. Fixture filings can be a little different because if you're filing a UCC on fixture and it's actually
air conditioning units that are stored in a warehouse, then you're going to file that at the Secretary of State. But if it's air conditioning units that's attached to a building, chances are you're going to be filing that at the local jurisdiction. So it can vary. We have a whole nother presentation just on fixture filing. So know that there are some questions that surround it, but just remember if it's in a warehouse somewhere not being utilized yet, it's probably going to be filed at the Secretary of State. But if it's used, an air conditioning unit that's attached to a building, you're going to be filing it generally at the local filing office.
There are other things. Real property, of course, is going to be filed at the local filing office. So if you have a lot in a block, you're going to be filing that at the local office. Any type of federal or state tax lien or judgment liens, they can vary depending upon where they file, based upon the jurisdiction. And once this call is over, I will send out a chart to Clint or to Hoxar, and they can get it out to you guys that talks about where you go to look for certain lien types based upon the jurisdiction. And then, of course, there's litigation that can be state or federal, and then bankruptcy is federal. And then we have a lot of other liens that are out there that sometimes people don't remember: mechanics liens, EPA liens, judgment liens. There's other things that are out there, and they can be filed in different places. So you just have to ask and find out when those come up. So let's look at the search logic that's put in place by the jurisdictions, or should be put in place by the jurisdictions. When you submit your UCC and you have the name on your UCC that is straight from your formation document, that is the name that you submit. But behind the scenes, the state should be creating what we call a filing key or a search key. They take the name that you submit, they do some things to it, like remember the punctuation, the spaces, the IACA noise words, which I can send you a list of, things like limited liability and corporation. All of those things should be dropped to make it easier for the person who is searching to be able to find the name.
Some jurisdictions follow this, some of them don't. As I said, this is something that's pushed out, and then they determine what works best for them.
So when we did a case, and just to find out what would happen if we searched Smith &Smith, what would we find? Will we find filings that have Smith A&D Smith? Because in the guidelines that are initially established, the A&D and the ampersand should be interchangeable. And you can see by this example that we found that some of the jurisdictions are following the model rule. In Illinois, the A&D is equivalent to the ampersand, but the ampersand is not equivalent to the A&D. So there is a variation there. In some states, it's the opposite of Illinois. And then in other states, they're not equivalent at all. You may recall one of the cases that we just talked about was in the state of Wisconsin, and the and the ampersand were not interchangeable.
So that means you have to know exactly what it is in order to find it. So it can be kind of tricky when you're out there doing searches. I find that oftentimes people are very comfortable when they're doing filing and searching within their state and the state that they're used to working in. But then when it gets across state lines, sometimes it becomes a little blurry just because of all of the variations. So just bear that in mind if you find that you're having to branch out beyond your own state.
So some common mistakes that happen: the and versus the ampersand, making it plural, adding an S, using the DBA or the FKA. You don't want to do that. Punctuation, sometimes that can be a problem with the spaces and the commas and dashes. Numbers, sometimes you don't know, is it a Roman numeral? Is it just the number 1? Is it the spelled out 1? So there can be variations with numbers. A couple of things that we recommend is that you do run a search to reflect when you've done a filing. What that's going to do is that's going to make sure that your filing was indexed properly. Know that when you submit it to the jurisdiction, you may have every T crossed, every I dotted. Sometimes they will do abbreviations that will make it difficult to find. I had one out of Florida where a customer had filed a UCC, and in the name of the UCC was, or the debtor name was manufacturing. West Virginia abbreviated manufacturing to the point of where it couldn't be found using their own search logic. So because the third party was diligent about checking on that, they were able to get that corrected. So be careful when you are doing that and make sure that it has been indexed properly. Now, with all of that said, just remember what I said when we started. Article 9 applies to a consensual relationship, secured party debtor collateral. If it is anything other than that, if it's a federal state tax lien, judgment, mechanics liens, all of those will not apply to the logic that I'm going through, specifically with the name, is not going to apply to all these different searches. So you need to be very careful when you are looking for these type searches that you're being diligent in your search, doing a broad search, and know that the IRS can put a name on a UCC that might not be the actual name off the formation documents, and that is okay for them to do. All right, so let's do polling question number 3. Common mistakes made when searching include using DBA names,
adding an S to the end of the word, using incorrect form of a number, or D, all of the above. Let me read that again. Common mistakes made when searching include A, using DBA names, B, adding an S to the end of the word, C, using incorrect form of a number, D, all of the above. And Rachel, just let me know when you close that out.
Okay, 95% chose D.
Very good. Okay, great job. Okay, so hopefully everyone has done all three of those polling questions. That's all that we will have, and that will be part of the way that you get CLE credit. So thank you for participating in that.
So let's go to our last section, which is post-filing changes. And I hope I'm not going over too much. We were a little late in getting started, but let's talk about what happens after your transaction or your deal has closed. So all the documents have been signed, and guess what? Your debtor goes in and they change their name. So they have changed their legal name. What you need to do is you need to file an amendment, a UCC-3, to get that name correct in the jurisdiction. And you have a 4-month window in order to get that name changed. So you want to make sure that you get that UCC under the correct name. I'm sure somewhere in your security agreement, it probably says that they need to let you know if they change their name. You may not be the first one they call, but hopefully they'll let you know, and then you need to go ahead and get that amendment filed to get the name correct. Another thing that may happen after the deal has closed is maybe they change where they actually are incorporated. So let's say they're incorporated in the state of New York, and they decide that they want to go and incorporate in the state of Delaware, because Delaware is where everybody wants to be, right? So they move from their incorporation or the formation from New York into the state of Delaware. Again, if your UCC is in New York, you're going to be fine for 4 months, but by the end of that 4 months, you need to have a UCC filed in the state of Delaware, and make sure that you have indicated on your Delaware filing. My suggestion would be that you indicate that there was a filing in New York and you're moving it over. Let's go through our conclusion. Just remember that when you are reviewing information on liens, that you need to look at the filings and all of the attachments. The face page of the UCC is not the entire story. Oftentimes, it may even require that you call the secure party to get more information. The debtor name, you want to make sure that you get the debtor name right. You look at the formation document and anything that could have amended that formation document over the years. You want to make sure that you run not just UCC searches, but that you also run searches that are not just UCC, because sometimes those can be a big factor. If you are planning to go into a transaction with a particular debtor, you may want to know if they have a bankruptcy, or you may want to know if they're involved in certain litigation. So you want to include those different type non-UCC searches when you are looking for different liens. Remember, if you're working with a debtor that is outside of the United States, there are three countries that have something similar to ours, but again, it doesn't mean that there's nothing else you can get. There are other documents that are available, and you can get help on translating that information from a service provider. Remember that you may want to run searches to reflect to make sure that your UCC has been indexed properly. And when you do that, you want to make sure that the through date that you're looking at is past the date of when your UCC was indexed, in order that it will even be there. Remember, you have a 4-month window to change the name or the governing law for a particular debtor after the transaction is closed. And then with multiple secured parties, be very careful, specifically with the terminations that we talked about, that each secured party has authorized that particular termination before you think that it's terminated.
And that is all I have for you guys today. I so appreciate your time. Certainly, if you have any questions, I know Hafgar and Clint were watching the box for me. I can either answer them now, or they can send them to me if there's any, and I will get back to you. I do appreciate your time, and anytime you want to contact me, this is my email address and my phone number. and I am more than happy to work with you and to help you. I will be getting you guys some documents. I'm going to be sending out where to go to search for the most common type liens so that you have that. And I also will be sending you a list of what we call the IACA noise words, so you know words that should be dropped when you're doing a search. Not always does it happen, but you should have a list of those as well. So again, thank you so much for your time.
Thank you so much, Beverly.